jury trial next week.
There's new evidence regarding this case that was discovered.
We recovered an iPad, evidence of trading coins stolen from a burglary, text messages between Ms. Mitchell and Mr. Gordon's mother, admitting that she helped him run. She lied in court to protect.
4 days from the scheduled start to a trial, Greenwood County DA Jill Gillette dropped some bombs on the defense. To be fair, they weren't really bombs so much as landmines the defendant buried and then forgot about. I don't think this young man really sat down with his lawyer and completely enumerated all his crimes, so the fact that his lawyer is playing catch-up is nothing new. We see it all the time. They will get to the bottom of things, but it sounds like this guy's chances at trial just became dog shit.
Fact that we're ready to go on Mr. Gordon's case. It is 2025 CR 38, State of Kansas versus Colt Daniel Gordon. State appears by and through Ms. Gillette. Mr. Gordon is present. He's currently in custody. I'm not sure what exactly he's in custody on or what all he's in custody on, but he appears from the Greenwood County Jail separately from his attorney that's appointed in this case, Mr. McClendon. We did set a jury trial next week. Today is pretrial conference. Announcement to the court, Mr. McClendon.
Yes, Judge. I was made aware by Ms. Gillette that there's new evidence regarding this case that was discovered late yesterday. I've yet to receive it. We want to call ready for trial, but without seeing this evidence, I do not feel comfortable doing so, and neither does my client.
All right. What is this new evidence that's come to light that you're asking for the continuance, Ms. Gillette?
Yeah, we have had recent interactions with Mr. Gordon. As you know, he's back in custody. We recovered an iPad from the vehicle. There was a search warrant on that iPad looking for evidence of buying, selling, and trading gold coins and other coins stolen from a burglary and a residence. And when the search warrant was executed on the iPad, there were text messages between Ms. Mitchell, who's here today, presumably to try to ask again for the no contact order to be lifted, and Mr. Gordon's mother, admitting that she recently helped him run, that she lied in court to protect him on the preliminary hearing in this case, and other information that was gleaned from that iPad. I was made aware of it yesterday. The new cases came over yesterday with many items that have started to be turned over to me. They have not done a full and complete download of the iPad, but they have photographed some of the text messages that are within the iPad. And some of those include text messages regarding the gold coins, trying to buy and sell and trade those, as well as vehicles and guns by Mr. Gordon. Ms. Mitchell presumably has assisted him in running from the police and fleeing, which he has now been charged in a fleeing possession of a firearm and violation of the protective order in 2025 CR 170 that was served on him yesterday. There's also a new burglary, arson, theft, violation of protective order and gun case, 2025 CR 164. He has had a first appearance on 164. He is scheduled for first appearance on 2025 CR 170 for Tuesday. But there has been a multitude of evidence gleaned from that iPad. And as I said, that is all newly discovered evidence that was recovered. And when we were able to access the tablet, it was full of messages.
Okay, so hang on. Let's go through this. Let's start with We were last here on this case, 25 CR 38, case assigned to me
Yes.
on July 17th of 25. That was his arraignment. He was appearing by Zoom. He was on bond.
Yes.
Okay. He apparently between now and July 17th has gone back into custody.
Yes. On new cases.
Okay. So his bond has not been revoked in this case.
Not by this court, no.
Okay. And so he is not being held solely on our case. And so I believe we're still looking at 6 months to try him. So we need to try him by December, August, September, October, November, December, no, January 17th of 2026, if my hand counting is accurate. It's not really 6 months, it's 180 days. As far as I know, I don't think that changed. What changed was in custody time from 90 to 120, but I don't think out of custody has changed. And then there's always an overriding constitutional consideration. But I've never seen a court say if it's within 180 days, it's unconstitutional. So statutorily, 180 days is what we've got to try the case, unless the request for continuance is by the defense or is caused or created by the defense. And then the court can continue for 30 days because of scheduling. So I could theoretically go to February 17th of 26 if I don't have a date by January. And then the state gets, I can't remember that part, but because usually when they get continuances, we still try to stay in the 180. But I think there's a provision for the state to take either 60 or 90 if there is evidence that they could not have procured or witnesses that they could not have secured prior to the request for continuance. I would have to look at the exact language of the statute. But what I need to know, though, from you, Ms. Gordon, or you, Ms. Gillette, is on Mr. Gordon, what about this new information you've got pertains to a charge that involves one count of domestic battery, other than potential, I mean, you can't really impeach your own witness. So, I'm trying to look at the information here. We got one count of domestic battery. It's a felony because there are two priors, so it's enhanced, but it's a simple battery enhanced. Actually, it's alleged there are three priors, but at any rate, I would assume, as the defense attorney, I would not want to go into a trial knowing that he's got new charges that you don't know how this conviction could impact all of that. Secondly, that if there is information that the prosecution has that you don't, that you haven't been able to study, that involves the same or similar witnesses, it would be nice to know what they know. But I'm not sure the new crimes are admissible in this case. And so what I'm trying to figure out, Ms. Gillette, is why you believe that the case should not go forward, or why you think the new information would be relevant to my trial that's scheduled next week.
The part of the new evidence that's relevant to our trial here is that Ms. Mitchell had made admissions. Mr. Gordon's mom, and there are texts from her that she lied to protect him at the preliminary hearing in this case when she was trying to deny that what she said on the video was true. at
Okay.
the hearing. And that's going to be the crux of their defense, is that.
So potentially inconsistent statements, but you can't impeach your own witness. That's the problem, unless they're declared hostile. And there are a couple other reasons, but I would have to look at inconsistent statements for your own witness that's the victim, and kind of where we're at on that. If you would get to it, it would depend on how she testified at trial. It's usually the defense attorney that wants to make a liar out of a prosecution witness. So I don't know. I guess I'm going to ask you this question, Mr. McClendon, because I can't always rule on the admissibility of things until we're actually in the heat or trial itself. Let me ask you this question. Are you willing to, after talking with your client, request a continuance of the trial of this matter? Or are you said you're ready to go to trial, or do you believe that it should be at the request of the prosecutor? So I have to know who's requesting this continuance if we don't go to trial next week.
Judge, the evidence that Miss Gillette is referring to is primarily our case in chief, and would be, put it this way, I think it's either going to make or break our case. And so without having those text messages, I think it would, I would like to go over it with my client so we could possibly consider alternative resolution. So that being said, Judge, I guess we may be requesting a continuance ourselves, just because we don't want to risk a conviction, because in 4 days we're supposed to be having a jury trial, but we have this evidence that is newly discovered and haven't had any time to think about alternative resolution for this matter.
All right. So Mr. Gordon, you are on bond in my case. You're not in custody on my case. Are you going to concur with counsel that you want to request a continuance of your jury trial next week on this incident from February 5th of 2025 involving a battery of Tavia Mitchell?
Yes, Your Honor.
Okay. So for right now, anyway, I'm going to show, it's a mutual request, but I'm going to show it attributed because it would be a specific request by the defense to continue the case, to review any other evidence or any other charges by counsel at the request of Mr. Gordon for speedy trial. And then what I need to know is what my trial dates are in Greenwood. Hold on. I think I have a book that might show me, but not. Let me look, see if I can find it here. Jury trials, Greenwood. I have one this month, which is what we're talking about today for next week. And then I don't have my 2026 calendar yet. Or if I do, it's not in here.
You have a Greenwood Elk County jury trial scheduled January 6th, 7th, and 8th of 2026.
Really? Because I think
Yes.
that was for 25.
Yes, we typically fall in January for Greenwood with how they fall the year
Okay.
before.
Okay, so because I showed January 7th, but that would have been for 25. But you're saying For 26 then. Now I'm going to 26 January. Our trial in January of 26 is when? 6,
Jan-
7,
Yes, January 6th, 7th, and 8th of 2026.
can you make that work, Mr. McClendon?
Yes,
Seven.
Judge. I mean, it's so far out.
I know.
I'm sure.
We
I'm
all-
sure where it gets honestly a little further than we want to go.
Okay.
But
Well, I'll tell you, I have asked numerous times from the chief judge that we add 2 dates a year to Greenwood that any judge can use. It's been decided that we're going to stay the way we've been doing it. And that means that I have 3 dates a year. And it is a big hassle if I try to use somebody else's date, because all of their cases they schedule get to come first. And then I don't know whether mine's going to get a go or not. And it just doesn't work very well for the defense attorney or anybody, frankly, because then I got to block out time that I would be doing other stuff and then may not go because we're not the priority. So, part of it is because of the limited amount of jurors, they only want to bring in jurors once a month for a trial. So we get 1 week a month for somebody to try a case. So that's just so you know the background. All right. So we always start or try to on Tuesday, 6, 7, 8, 2026, 9 to 5. That'll be the jury. Now we have to go back to the pretrial. Because obviously I set more than one case over in Greenwood because I have so many cases. So we have to sort all of that out ahead of time.
And with all of your holidays,
And
your
New
trial-
Yes.
you'll be looking at December 11th for a pretrial.
Okay. Unless we do something special, which we can never do because of Miss Gillette's always tied up.
Right.
Okay, so it looks like we're gonna do pre-trials December 11th for all of our jury trial cases in January. Does that work for you?
I will have the Friday morning before jury trial if you want special settings.
Okay.
The
Well,
January
With
2nd,
the holidays, that is, let's try to see what we can accomplish December 11th. And if we have unknowns and we have to, try to save a few hours at least for me the Friday that you're talking about, which would be what, January 2nd? Or January?
Second, Judge.
I'm talking about the 2nd.
January 2nd? Okay. Save me a few hours on January 2nd in case we have unknown announcements, but that we can take care of in December, we will. So I'm going to set this for a pretrial December 11th. I have all day open, so you get to pick the time.
Do 11, Judge.
11. December 11 at 11, Mr. Gordon, if you make bond, or if you get out on your other cases, I'm continue on your bond because I don't have a motion to revoke that bond in front of me at this point. For you to reappear in this case, December the 11th, and I do want you to come to the courthouse for this. I don't want you appearing remotely by Zoom, please.
Yes, Your Honor.
At 11 a.m.
Just
Okay.
to confirm, Judge, it'll be an in-person hearing for all parties, correct?
Since it's going to be a pretrial conference, I think so, yes.
Okay.
That's
So
good.
in person for everyone.
Huh?
In person for everyone, Judge? Is that what
Yes.
you just said? Okay,
Yes.
just want to make sure I had it in my notes.
The plan. Now, sometimes when we get close to dates, we end up with lawyers that don't want to come in person or have a conflict. And then if we get all but a couple of cases end up by Zoom for whatever reason, then sometimes we switch them. But we let you know when we get your consent. We don't do it without without your consent. But I do like to make sure defendants in any case are ready to go to trial. Usually it's the week before, but I'm able to look them in the eye and say, you know, I expect you to be here, and I know they've shown up, so we know they haven't disappeared. The other thing is that I like to take felony pleas in person, especially if it may be a questionable probation situation. I like to sentence in person if it's not a very simple presumptive probation case, and I like to do revocations in person. Again, background. All right, anything else to come before the court at this time? All right.
Not at this juncture, Your Honor, but may I have a quick breakout with Mr. Gordon before we conclude? Yeah.
And if you have any motions in limine, or Ms. Gillette has 6455, or, you know, I'll always find you time before then for hearings that we need on this case. But we're putting in a breakout because what do we have next, Amy?